Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Alrighty, I think we're almost back. Welcome back to the Court of Public Opinion. Happy Tuesday. Yes, it is Tuesday. I am the Recovery Addict. Thank you very much for joining us this afternoon. Put all the parts and pieces together here. Just one second. Big shout out to Kim R, who's first in chat today. Congratulations once again, Kim. Appreciate you being first in chat. We're going to send you to internet ownership for your promptness. Yes, we are punishing you for a good deed. But no good deed goes unpunished, as they say. So excited about that. Welcome back. Welcome back. We have a few things going on. First of all, beautiful day outside. Hopefully you all enjoyed a wonderful lunch. We had just over an hour. Sorry, I was a minute or two late there getting back started. But we're all set up. Congratulations, Kim. The internet's all yours. Let's see where we are. Back up, see what I missed. Anything. Cass says number 50 on the DNA, number 52, 54. I see you guys clicking the like button, spreading the DNA goodness. Took a nap in my hammock for lunch. That sounds wonderful. I love a good hammock. A good hammock requires proper tree placement. I mean, it takes years to get a good hammock stand, unless you go with the commercial ones. Let's see. Kim says, I'm in my hammock. I've spent many a pleasant hour swaying slightly in the breeze in a hammock. I've really enjoyed it. I think I even live streamed from a hammock at one point. Let's see. Evening from a dark and cold farm in Northumberland, says Mike. Not in a hammock. Hashtag not in a hammock. Great to be. Debbie, welcome. Or proper placement in the screened porch. Yes, that would also work if you're looking for no bugs. I tend to attach my hammock to trees that are also infested with ants, which makes hammocking less fun. What is it? Is it hammocking or enjoying a hammock? Can you make it a verb? I don't know. We'll need somebody to explain. Are we doing Carly Gregg today? I believe she's doing jury selection right now in Mississippi. Let me just double check that one. We've also got Mr. Redden, the courtroom jumper in Las Vegas. I think they just picked a jury, and they should start court tomorrow for the attempted murder of a judge trial. Let's see. She rejected the plea deal. She's going to go to court. I think we're still in jury selection. I haven't seen that come back with a jury yet. Just got to wait and see if they can get a bunch of people seated for that one. Let's see. Paula says, I'm supposed to be working. Boss put the hammer down this morning. Do we ever get closure on the Fortnite streamer? I think he got another date, pushed him out. His lawyer, I I think his lawyer helped him out. No, that was the other guy. That was Bob the Builder. I don't know what happened to the Fortnite streamer. Yeah, they may have been showing an older hearing. I don't think anything's live with Carly Gregg right now. Carly Gregg. I can't say your name for the life of me. I was waiting for one little court that just barely popped up. It's the 13th Judicial out of Kansas. We're hoping for something out of them, but as soon as we went live, they went here. Oh, that's not it. They went here. Boop. Honoris, whoever that is, turned off the camera. I think we're waiting for the jail to come back online for that one for some hearings. Probable cause, I think, hearings. So we'll keep an eye on that one. Happy birthday, Gailey May. I believe we sung to you this morning. Court jumper is today. The court starts tomorrow. So they were live today with jury selection. It looks like they've seated a jury. So court will start tomorrow afternoon. And I don't know how many days that one's going to go, the attempted murder. Because, I mean, you've got everything caught on camera. Not just, it's one thing to have a crime that's caught on camera and you've got this evidence. It's another thing to be caught on camera on courtroom video with bailiffs in attendance and have that be the evidence against you. So I imagine it's going to be a shorter trial, but they are pleading, I think, insanity on that one. So we might have some experts testifying to that front. 61 candles would probably ruin the frosting. Yes, at that point, everything just lights on fire. I've had to stop. You have to buy the candles that are shaped like the number. That's the only solution. Yes, it makes a mess of the cake because it needs a big, huge, like, you know, in my case, the first number is a 4, and you know it's a huge candle. But you can't just do a billion candles because then it's a fire hazard. Is that the guy that Superman flew over the bench? Yes, that's him. That's Mr. Redden. He's been his appearances in court after that. He's been he's had a spit mask and been shackled and had a whole football team of bailiffs accompanying him. No worries. I think some of the channels that are covering it have actually put a thumbnail up for tomorrow already, but they're 24 hours early. So they're just saving their space, which is cool. So we'll keep an eye on that. That's what's going to be tomorrow afternoon. Oh wow, this is great news. You ready for this? This comes from Roz Alerts, by the way, which is an amazing Twitter channel. If you don't follow Roz Alerts, they're great with breaking news. Officials say that the temperature in Phoenix, Arizona has reached 100 degrees Fahrenheit for a record 100th straight days, shattering the previous record of 76. There you go. It's hot as blazes. It's hot as blazes down there. 100 for 100. That is hot. It's hot. 100 straight days. Previous record was 76 straight days. Why do people live there? Well, apparently they don't live very well. No, thankfully we have air conditioning, or most of us, which is all good. I've still got my fingers crossed for Kansas. I was hoping they would come back here, but they're not. I might have to check another court for you. Okay. They should be back any second. I don't want to leave this one because they looked juicy. It looked good. Is it a dry heat or a humid heat? It is dry. Like suck the moisture out of a rock dry. There's Judge Speedlin Gonzalez, who is live. Wonder how long his trials take. It sucks, by the way, says AZDCS Oversight. It's just hot. Just nobody goes outside. Carly Gregg is very interesting as far as that trial goes. A quick just recap of that trial. 14-year-old girl charged with shooting and killing her mom, who was a school teacher. Shot her 3 times, quite intentionally, then called a friend, said, hey, do you want to come see a dead body? And then also attempted to kill her stepfather, shooting and injuring him. And she's rejected a plea deal, so it's going to trial. The judge down there in Mississippi has said, yep, the courts belong to the people. Transparency is important. Cameras are allowed. I don't care if she's 14. Come on in. And so we have a 14-year-old defendant who, by all records, looks like she's maybe 9 or 10. Okay, and she's being dressed by her legal team. I'd say great work, by the way. You make her look like even younger than she is. You make her look like an elementary school student instead of a junior high student. Oh, here's a trial we won't be following, but there's a press conference right now going on for out of Los Angeles. It just says authorities provide update on murder of couple who vanished from nudist ranch. Vanished without a trace. And the sad thing about being, vanishing from a nudist ranch, there's no clothing to find. I mean, I don't know, maybe it's too soon for that joke. You're no fun, says Tisha. I mean, clothed people, when they go missing, you're like, hey, they were last seen wearing. There's nothing. I mean, what do you put out? What do you put out in the bolo? Okay, it's like, hey, be on the lookout for some buck naked peeps. That's it. That's all you can put. You really can't do much else on the description. So it narrows it down, says Greeners. She came to court in her plaid Catholic school jumper. They are not messing around. Yeah, I'm serious. They really are. Oh, I just missed we've got a call. Let's see who this is.
Call from.
She'll tell you.
Donnie, what's up? Hello?
Hi, this is Karen. I'm just checking in to make sure Donnie is behaving himself.
Karen, I am so glad you called. Thank you. First of all, you got my message. We do have some concerns. Did you get the email?
Oh, we do.
Yeah. I emailed you to confirm the address because I got a whole packet that I've printed out of just, we've got some of it's transcripts mostly of what's happened. It's easier to read it when it's in type.
I do apologize. He must have interceded my emails because, no, I haven't gotten either one of those.
Dang it, Donnie. Well, Donnie's been Donnie. I don't know what else to say. So
I don't know how to be anyone else. I get paid for this, but thank you. I don't want to take up any more of the time. I'm going to leave you with Karen. She's the assistant. She lives in here, and I pay her.
Mm-hmm. Oh,
Karen,
yeah.
We love Donnie. He's good fun. He always interjects some barely appropriate humor, and.
Well, just so you know, he does have, I give him a nickname.
Uh-huh.
His nickname is Sasquatch because I'm 5'2". He's huge. He's 6'4".
6'4". Wow.
Mm-hmm. Yeah.
280 pounds, 270.
Oh, he tries to call himself fat, but he's not. He's a little thick, but Sasquatch is usually.
I'm like hot thick.
Is it 6'4" with or without lifts?
Without.
Okay. Sounds good. Thank you. And it was Karen, right?
Yes.
Karen,
So I do apologize. Yes, Donnie is going to be Donnie, and I try to save everyone, but there's no hope.
There's no hope. It's all right. He keeps it barely within the lines. As long as he does that, we're perfectly fine with it. So we appreciate that.
Oh yeah, he has learned the line. Believe me.
When you know your limits, the world is your oyster. So there you go.
Yes, absolutely. All right, honey. Thank you.
Thanks,
you have
Karen.
a wonderful day.
You too. We'll see you. Bye.
Bye-bye.
Look, glad someone's looking out for Donnie. Mostly looking after Donnie, I think, is what it was, not as much as looking out for. But love it. Thank you very much, Karen, for the call. Thank you, Donnie. Blackbird squeaks as we wait for court, which has finally come back in Kansas. Let me show you as we get everyone set up. Need suggestions for dinner? Home cooked, have chicken thighs or a pound of ground beef. Okay, now we've got one more call. Hang on.
From Emma to accept.
Hey, Emma, this is Recovery Addict. How are you doing?
Hi, Recovery Addict. I'm also misconduct.
Yes.
Also fun and funky.
Mm-hmm. Welcome.
Thank you. I hope you're having a wonderful vacation.
I'm not. I'm just working. It's regular work for me, but my family's having a great time. So no, I've had a little bit of fun.
That's not the right answer.
I can't call this whole thing a vacation. I'm just working away from home, but I love what I do. So I mean, I really can't complain.
Just the Sarah Boone thing. What do you think?
I think Mr. Owens has his hands full. I think there will come a point where he's like, you know what? Those other lawyers were right. You know, I should have ignored the advertisement and just said, you know, this one is not for me or for anyone else for that matter. So it's going to be fun because here's what I think. I think she still wants to testify. Even though she has a lawyer she likes, she's not going to change her mind. She's got a story to tell, and she's got a way she wants to tell it, and it will hurt her case. And he's going to tell her not to do it, but she's going to do it anyway. So
she's going to say GTFO. That's the polite way of saying it, isn't it? Yeah, GTFO. Yeah.
Yeah. I don't know. I don't think she would fire him at this point. Because I think now she sees the writing on the wall. The judge will not let her get anyone else. There's no delays. They're not letting him stop and say, okay, give us a minute to get up to speed. Give us a minute to get an expert ready. He's saying, nope. You knew what this was when you picked it up. And we're running with the existing date of October 7th. So I don't think she's going to push to get him kicked off as much as he's going to be like, I just can't do this anymore. She is so demanding.
I think... Apologies. No, but I think that's where you're right. The judge, even though the new lawyer has said he wants a continuance, he said, absolutely not.
Yeah.
I told you this. I told her this. Absolutely. I told her this on blah, 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 August. No. You do it or you don't.
Yep, I think she made her bed. Now she has to sleep in it a little bit. But I do like the fact that she has a lawyer. That I feel better about that.
So do I.
Mostly because
so do I. To be fair,
there was like a big question of like, will she get an appeal? Okay, because the way it went about with her not having a court appointed lawyer was pretty shady. In her eyes. And so I'm like, does she have grounds for an appeal at that point? I'd hate to see this dragged back through the system again, all because an appellate judge looked at it and was like, I don't know, I didn't like how you ruled that she wasn't eligible anymore. So I'm glad that she has a lawyer, and we'll see how it goes. I think the trial will be more enjoyable to watch with a lawyer than with a pro se who doesn't understand the process all the way through.
I agree with you, and I hope you have a good afternoon. What is it? It's 9:10 here, so it's
getting a bit
3:10. Yeah.
Yep.
Yeah.
So it's only 2:10 here because I'm out west. So.
Oh my goodness me!
Yeah,
I've
the day is
done
young.
My work.
I've got half the day still ahead of me. So, thank you very much, Fun and Funky Emma. Misconduct, all of the above.
You.
Yep, love you too.
Bye.
We'll see you. Bye. All right, so now we're going to jump over to Kansas and see what's happening in this court. The lawyer's got a guitar on the wall.
Further than the Alfaro matter is in recess. We'll move on to another matter.
Oh, good. Just perfect timing.
Mr. Watts, do you have other cases on this docket?
Well, I have the sentencing for Mr. Booker.
Okay, can we get Booker in there?
Can the sheriff bring in Booker? Booker needs to be booked. James Watts needs a new chair. His headrest has worn thin.
See. Good afternoon to you.
Jaylen Booker. Mr. Booker?
Yes, sir.
Okay, so make sure we could hear each other. I will call at this time State of Kansas versus Jaylen Kawan Booker, case number 2023 CR 300009. James Watts appears as defense counsel. Mr. Booker from the jail Zoom location. Amber Norris on behalf of the state. On January 2nd of 2024, Mr. Booker appeared before this court and pled guilty to count 1, felony theft. A level 7 felony. Pre-sentence report was ordered. Sentencing originally set for March the 11th. March 11 docket notes indicate that the defendant failed to appear, and the defendant failed to make his March 7th appointment to complete his Senate Bill 123 assessment. Court ordered bond forfeiture, bench warrant, no bond hold. Sentencing would be rescheduled when Booker was taken into custody. Apparently, there was an appearance before a different judge, Judge Crum, on August the 12th. My office wasn't contacted about a sentencing date, so apparently we just sat here on this preliminary hearing docket. But I do have a prosecutor, defense counsel, and the defendant. I think I'm inclined to go ahead and proceed with sentencing at this time. And I trust the defendant has had an opportunity to confer with counsel today.
Judge, we haven't, but in terms of criminal history, he has none. Obviously, we will not be objecting to that criminal history.
All right.
He has no criminal history?
Does the state have any objections to the criminal history score as stated in the report?
No, Your Honor, it appears appropriate.
Very well. Court will adopt the criminal history as stated in the pre-sentence report and finds that the criminal history score applicable to today's sentencing is criminal history score I. Ms. Norris, do you know the legal reason why sentence should not be pronounced in the Booker case this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Mr. Booker, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, Your Honor.
Court will proceed further then. I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, Your Honor.
Are there any victims or members of a victim's family present who desire to address the court in relation to this sentencing?
Kit's nodding.
Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Booker, beginning with Amber Norris on behalf of the state.
Thank you, Your Honor. This is a felony theft. Would ask the court follow the presumption. And Your Honor, assign defendant to 12 months in the Department of Corrections. Defendant would be able to earn up to 20% good time credit and would be subject to 12 months post-release if necessary. And actually, Your Honor, let me go back. Obviously, it's been a while since we did this plea on Mr. Booker. State will be recommending the low end of the box, which would be in keeping with the plea, which I just found a copy of in the file. And Your Honor, based on the time of the offense, this defendant had a SASE as part of the PSI process. And based on his score, he is mandatory treatment. But it looks like with the change in the law, they're not doing up to 18 months for treatment. Now it's 24 months for the probation duration. Although I was kind of trying to clarify that with Kit before we went on the record, because all the previous mandatory SB 123 treatment has been up to 18 months. But obviously, if he wishes to address the court here in a minute, that would be great. This is only maybe like the second of one of these new, the new part of the mandatory drug treatment case law that I have done a sentencing on and that would fall into the appropriate category. Your Honor, he does have some jail time credit. It looks like it was 41 days as of today's date. And Your Honor, he is presumptive probation, asked that he be placed on community corrections for that supervision with all standard and PSI recommended probation conditions. No contact with the victim, no contact with the co-defendant. Your Honor, I will be requesting restitution in the amount of $1,311.66, joint and several with the co-defendant, Miss Timoney. She has not had her sentencing as yet, but she has already done her felony plea. And Your Honor, it looks like he would need to be responsible for the $200 DNA database fee and standard court costs, community corrections fees. The court would need to address court-appointed attorney's fees and the bid's application fee as Mr. Watts is appointed. And then there's the SB 123 reimbursement fees that totaled $300. Otherwise, Your Honor, I don't think I have any further recommendations. The LSCMI notes him at a 21, which on that particular form is considered high risk. He, on the SASE, he's in the high probability category. So we would ask that he just follow through on that treatment as
I didn't know they had jail outfits with polo
by
like
the
collars.
assessments.
He's got like a polo on, jail polo.
And otherwise, Your Honor, I don't think I have anything else for the court at this time.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Your Honor, consistent with the plea agreement, we would likewise recommend the underlying sentence of 11 months in the Department of Corrections with a post-release period supervision of 12 months and 24 months probation. That 24 months comes from the level 7 offense rather than the 18 months that's typically done on a Senate Bill 123.
Must be an armed robbery.
Like Ms. Norris, I've not done a lot of the new enhanced Senate bills.
$1,300 is a phone.
Certainly appears to fall squarely within it. So we recommend that he be placed on probation with that Senate Bill 123 and the drug and alcohol treatment portion of that, and a probation period again of 24 months. I have reviewed the restitution. Frankly, I had a question of the amount that is listed in the PSI as to $1,600, but given the state's recitation of the figure that we have there, I don't believe we have any objection to that figure. $1,300, I didn't catch the exact amount, but $1,300 and change.
Kit, what you got?
I don't know that I have anything else to add, Your Honor.
All right. At this time, the court will address the defendant, Mr. Booker, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
I have nothing, Your Honor.
Very well. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence for the offense of theft, a severity level 7, non-drug, non-person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 7I. The court hereby sentences the defendant to a term of 11 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered a fine, but declines to impose one.
Nice. That was nice of him.
The court does find that in grid box 7I, this is a presumptive probation offense under Kansas law. Court
You're in
also
Kansas.
finds that the combination of a high score on the risk needs assessment combined with the determination on the SASE of a high probability of a substance abuse disorder indicates that this is a mandatory case for drug treatment. Under the auspices of Senate Bill 123, the defendant is ordered to complete treatment as part of his community corrections supervised probation, which the court will order. That probation duration will be 24 months, again, supervised by the Community Corrections Department, due to this being a Senate Bill 123 case, and he must successfully complete a drug or substance abuse treatment program and any aftercare recommendations as part of Senate Bill 123 requirements. Other conditions of probation will include reporting to an officer as directed, observing all laws. He is not to possess or consume alcohol or illegal drugs while on probation. At his supervising agency's request and at his own expense, submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment successfully throughout his probationary term, notify his supervising officer of any changes in employment status, residence, telephone number, email address, or law enforcement contact within 48 hours, have no contact with the victim, Justin Rodriguez, or the co-defendant, Tamaya Madison Timoney. He's to submit his DNA to the KVI data bank and be responsible for the cost of the test. It's my understanding that the DNA is on file at this point. He must abide by any curfew or travel restrictions imposed by his officer, follow all standard conditions of probation, not have in his possession firearms or dangerous weapons, avoid disreputable characters and places, make monthly payments on a payment plan as established by the court, and again, follow all Senate Bill 123 rules, regulations, and requirements. Furthermore, Mr. Booker, we could have had this sentencing back in March if you would have complied with court orders. I don't know what the reasons were in your mind that you didn't think a felony sentencing was that important, but you didn't complete your pre-sentence requirements. And here's a case that was pled in January. We're supposed to go to sentencing in March, but here we are in September, finally addressing it. And really, and primarily, Mr. Booker, it's because you didn't do what you were supposed to do. I think you realize that now. Because of it, you've served an additional 39 days in jail, but the court's not satisfied with that, Mr. Booker. The message needs to be made clear here, Mr. Booker, that when you're ordered to do something, that you do it, because thus far you have not gotten that message. Kansas law allows this court to order 60 days as a condition of probation, and the court's going to order every one of those days here due to your total noncompliance with the pre-sentence investigation process. I have no doubt, Mr. Booker, that at this point you probably do regret those decisions, but you've got 19 more days to do because you've got 41 days of jail time credit against the 60. I'm going to order you to remain in jail to serve out 19 more days to complete a full 60-day sanction imposed as a condition of probation. Again, 41 has already been served, 60 to be done total. He's got 19 more days starting today. Then, Mr. Booker, I'll order you that as the first thing you do when you get out, you need to contact the Community Corrections Department. If it happens to fall on a weekend or a holiday, you need to contact them the very next business day after you get out.
Yes, sir.
Assessed in this case is a felony docket fee, felony probation fee, community corrections fee, $200 DNA fee, $300 reimbursement of Senate Bill 123 costs, a restitution in the amount of $1,311.66, joint and several, with co-defendant Timoney. Mr. Booker, what kind of work do you intend to do when you get out?
Any work that I can get my hands on, really. I've thought about applying for a fast food job just to get me started and just going from there, seeing if I can get a higher paying job.
All right, you've got a considerable amount of assessments here. You're going to be on probation for a while. I think I need to require at least $100 a month from you. However, just given the court's orders today, I'm not going to start that until November as a requirement. So starting November and each subsequent month, you need to pay at least $100 a month on this case until you have it paid in full. I do like your attitude regarding work. Mr. Booker, I wish more young people had that attitude to take whatever work is available as a start and then improve themselves along the way.
Amen.
It's a requirement of you to be working and being productive and paying on the case. So it's not like you have options. You've got to work to earn your own way legitimately, because obviously you can't steal anymore. That's just going to get you in even bigger trouble.
Elvin Summer Moon, thank you very much.
I don't know, Mr. Klossing, that we can set up a breakout session with the docket still going.
Okay.
Can we write down at least a number that the jail can give Mr. Booker to call when he gets out?
Yes, Your Honor. Yes. I can take that down.
Ken, if you give the number, please.
Yes, 316
867 5309.
Hey, Mr. Booker, first business day after you get out, you've got to call Community Corrections and ask for Ken. Mr. Klossing? Yeah, okay. He says yes. Okay.
Yes, Your Honor.
In Your Honor,
you can get started with your supervised probation at that time.
Mr. Watts needs to speak.
If I can interrupt, Your Honor, and I might have missed it, was there an attorney fee and a biz application fee established?
There was not. I'm waiving those.
Okay. Thank you.
Given the amount of these other assessments.
Thank you.
Wow.
All right, I've got some additional rulings to make at this time. Of course, I already dealt with the issue of jail time credit. Some point in the future, Mr. Booker, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under limited circumstances, a criminal defendant has a right to appeal a conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on an appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal the sentence if the court has ruled adversely to you at this hearing. I'll remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, are you aware of any other sentencing-related matters that the court still needs to address?
Your Honor, there is a motion for judgment on bond that was filed a while ago that has a hearing date in October. We would just move to withdraw that on the record here today, and we'll just have the journal entry reflect that that's been withdrawn and to cancel that next hearing.
Well, I'm already trusting that Mr. Watts will have no objection to that, so I'm going to order that motion for a judgment on bond be withdrawn. If you'll submit an order in due course, Ms. Norris. Mr. Watts, anything further?
No, Your Honor. Thank you.
Ultimately, Mr. Booker, I want you to be successful on this. I would hope that you would just follow the rules from here on out, and so that you don't have to have your sentence reviewed in the future. Good luck with completion of an appropriate substance abuse treatment program. It would appear to be in your best interests.
Thank you, Your Honor.
All right. If there's nothing further, then the Booker sentencing matter will be in recess at this time.
All right.
You can go back down to your pod this round.
Mr. Booker's got some more time to serve.
Mr. Watts, I'm not aware that you have any more matters on this docket. Do you have any more?
I don't believe so, Your Honor.
I'm just here to observe.
I think Mr. Favre is going to take it home from here.
Mr. Favre has
So
a
you're
green
released from the
screen
meeting,
or
Mr.
some
Watts.
very,
Thank you.
very
That's
big
correct, Your
books
Honor. I
behind him.
note we have a 4 o'clock in your office.
Well, if I'm
Docket
done,
is complete. Yeah, if you're done.
It's a golf appointment.
Yes, sir.
come on over, Mr. Watts, and you can just wait, and I'll join you as soon as I can.
Bring your clubs.
Yes, sir.
Yep. Looks like a co-ed jail. That's what we got going on.
Okay, I have a female individual at the detention center. Which one is this?
This is Mrs. Taran Brown.
The state of Kansas versus Taran Janet Brown, 24 CR 82. Amber Norris appearing for the state. Joseph Favre's defense counsel, and defendant Brown appearing from the jail Zoom location. What is the announcement made here?
Judge, Ms. Brown at this time has been advised for her rights to hearing. She'd waive her right to preliminary hearing. She's going to enter a plea of guilty to count 1, possession of cocaine, and we can proceed from there. State will dismiss remaining counts.
Is that correct, Ms. Norris?
Yes, Your Honor, that is accurate.
Very well. Ms. Brown, importantly, you've been present when your attorneys made an announcement. First of all, that you intend to waive your right to a preliminary hearing, which is a probable cause determination. Are you waiving that right?
Yes.
And is it your intention to enter a plea of guilty and accept conviction for possession of cocaine as charged in count 1?
Yes, Your Honor.
But I've got a number of questions I need to ask you regarding the taking of such a plea.
Okay.
If there's something you don't understand, I'll give you the opportunity to confer privately with your lawyer. Let the court know if you need that time to get further advice. State your name for the record, please.
Taran Brown,
And how old are you at this point?
23,
What's the highest level of education that you've attained?
12th.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing here in court?
Yes, Your Honor.
You think you will have difficulty understanding them?
A little of them, yes.
Okay, well, again, no one's trying to trick you or trip you up. I want you to understand and know what's going on. So if you don't understand something, let me know, okay?
Okay.
Have you ever been adjudged to be mentally ill?
No,
Okay. Are you currently under the influence of alcohol or any drug?
no,
Are you supposed to be taking any type of prescription medication that you're not getting?
no,
Okay. So you believe your mind is clear and that you do have a full understanding of what's going on here in court?
yes,
Do you understand the nature of the charge in this case, possession of cocaine?
yes,
All right. You understand that when you enter a plea of guilty, you are admitting that act that's been charged by the state?
yes,
You also understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that possession of cocaine charge.
yes,
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Favre, and that you can present evidence at a trial and present and subpoena your own witnesses to court?
yes,
She's doing well so far.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case under oath if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
yes, I do.
Understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
Yes,
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
yes,
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
yes,
You understand that you have a right to appeal a guilty verdict if you have a trial.
yes,
You further understand that you may appeal your sentence after entering a plea of guilty, but generally, you may not appeal your judgment of conviction after you enter such a plea.
yes,
Are you aware of the possible penalties that could be imposed as a result of this guilty plea that you're attempting to make?
yes, I am.
Let's go over those.
Maximum punishment?
Possession of cocaine, as charged in this case, is a level 5 drug felony. Under the Kansas Sentencing Guidelines Act grid, In the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the most severe criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you said today, Ms. Brown, we do not know with certainty what your criminal history is. You, better than anyone else here, really ought to know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of that research, as of the date of sentencing, that will determine where you fall, excuse me,
bless you,
along the level 5 line, and then you'll be sentenced accordingly. Do you understand that?
Yes.
You also understand that if you have a person felony on your record already, Ms. Brown, at time of sentencing, you are in a presumptive prison category.
I did not know that, but I do now.
Okay, does that change your mind about going forward?
No.
Okay. You also understand that you are subject to up to a $100,000 fine for this offense?
Yes.
Wow.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, I am.
Mandy, could you bring me a bottle of water, please? You also realize that as a direct consequence of this plea, you will be
get one
sentenced
for me
to
too, Mandy?
an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate at time of sentencing.
Yes, I do.
You also understand that both probation and post-release supervision periods start at 12 months in duration, but can run up to 60 months under some circumstances.
1 to 5 years.
Yes.
Probation.
You also understand that if there are any special sentencing rules under the law that apply to you, it could affect your eligibility for probation or otherwise affect your sentence.
Yeah, I do.
Now, did you have an ample opportunity to fully discuss your legal case and all of these circumstances with your attorney, Mr. Favre, before proceeding here today?
Yes, I did.
Are you satisfied with the services and advice given to you by him?
Yes.
All right, now the guilty plea that you're attempting to make hasn't been based upon any threats or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
Water's here.
Yes.
Okay, now we're not talking about plea agreements. I'm talking about, did anybody threaten you to do this?
Oh, no.
Is there any other promise other than the plea agreement that's been made to you?
No.
Okay. I want to make sure you understand that for any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. Court may and shall consider them as recommendations, but is not bound by them. You understand that?
Yes, I am.
So let me ask you formally, how do you plead to this charge of possession of cocaine?
I plead guilty.
Okay. All right, Ms. Brown, what did you do that would constitute that crime? Tell me what happened.
I had possession of it while I got traffic stopped.
Possession of what?
Cocaine
Okay, where was it?
in my bra.
Okay, and you knew it was there?
Yes, I
would
did.
hope so. I would hope you would.
It's not my bra.
And you knew it was cocaine, right?
Yes.
And you don't have the legal right to be possessing that cocaine, do you?
No, I do not.
Okay. According to the state's charging document, this took place around February 21 of 2024. Is that when it happened?
Yes.
And where did it happen at? Where did you get pulled over?
Butler County, I'm pretty sure.
Okay, well, tell me where.
On the freeway.
Freeway, are you talking about the turnpike?
I think it was, yes. It was on one of the freeways.
But you're not contesting the state's allegation that it was somewhere in Butler County, right?
No.
Okay, so do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for count 1, possession of cocaine?
Yes, I do.
Okay. Ms. Norris, do you know of any legal reason why the court should not accept this defendant's plea?
No, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Your Honor, no.
Okay. Ms. Brown, are you aware of any legal reason or any other good reason why the court shouldn't accept your plea here today?
No.
Court will accept the guilty plea made by defendant Brown.
We're in Kansas.
Finds that plea is made voluntarily. She has an understanding of the nature of her charge and the consequences of her plea, and a factual basis for the plea does exist. Court adjudges her therefore convicted in count 1 of possession of cocaine, a level 5 drug felony. Other charges are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to determine Ms. Brown's criminal history, and the court will set an appropriate date for sentencing. I wish I could just go ahead with it now, Ms. Brown, but I can't. There has to be a pre-sentence investigation and report compiled. It takes about 8 weeks.
Okay.
So I'm going to set your sentencing date for early November.
Okay, Your Honor.
Friday morning, November 8th, Mr. Favre. I can set it late morning at 11 o'clock.
Fridays are always dicey, but 11 o'clock would probably work. Let's do 11. Yeah.
Okay. Taran Brown's sentencing is set for 11 o'clock a.m. on Friday, November the 8th. Ms. Brown must obviously fully participate in that sentencing. Friday, November 8th, 11 o'clock. Ms. Brown, as part of this pre-sentence process and perhaps to determine Senate Bill 123, which is a treatment program, eligibility, you may be asked to do one or more assessments, a risk needs assessment and a substance abuse assessment. You are ordered to comply with those. It's in your best interest to do so, so sentencing does not get held up. I'll hold you responsible if it doesn't.
Okay.
So comply with those assessments. Friday, November 8th, 11 o'clock is the sentencing in the case. What's Ms. Brown's bond status right now?
So, Judge, Ms. Brown is on a no bond hold. She had previously failed to appear at her first PHC. Actually, she appeared, had some technical difficulties with her Zoom, and then was not able to get on. So she was there anyway, and then it was not able to go through. The court eventually issued a warrant for her. I have been in contact with her family, her fiance, as well as her mother, who is taking care of her children. She is going to be living in a sober living house. We're asking the court to set a bond for her at this time of a much lower amount, somewhere in the neighborhood her family can make. We're hoping for $2,500 cash or surety, or even lower than that. But the Miss Brown, this is her first ever felony. She is going to be either H or I box. She's been in custody for over 30 days at this point, I believe. So, like I said, she has a lot of resources, and frankly, the strain on her being in custody is hard on her family. So we asked the court to consider lowering her bond at this time.
State's position on the request.
Your Honor, I do expect her to be presumptive probation. And Your Honor, her bond previously was $4,000 cash or surety.
No objection?
I do not have an objection to the court setting a bond. I do think it should be a cash or surety based on the defendant's failure to appear. But I do not have an issue with the lesser amount of $4,000 or possibly even less. Like I said, she does appear to be presumptive probation.
That just means that when she's sentenced, it will most likely be.
Thank you, Ms. Norris.
Just probation.
Ms. Brown, I hate failures to appear. It brings progress on cases to a halt. Your case was filed, I think, back in February. We're still messing around with it in September without any real complications or delays in your cases that wasn't caused directly by you not showing up.
Agreed.
Okay, well, at least I'm glad that you admit you're the problem. Whether you should be given another chance on bond or not, that's really problematic. Ms. Brown, you've already demonstrated you don't necessarily take court-ordered obligations to appear seriously. I don't know how Mr. Favre can know that you're going to be in a sober living house. You have to be admitted to such programs, and with you being in jail the last couple of months, it could be that you might be able to get in. I'm a little bit unclear that you would for sure be able to get in, but that's not going to make a difference to this court, Ms. Brown, because I'm inclined to give you another chance. Your attitude's been very good today, Ms. Brown. I think you get it finally. I hope you do.
I do.
But I'll tell you what, here's the deal. I'm really worried that when you get out, you're going to forget all about the pre-sentence report. You're not going to do your assessments. You're not going to contact court services. You're not going to do what you're supposed to do. And then we're going to have a big mess on our hands again.
I'm on the right path. I've got this 2 months really did me justice. Like, it really got me sober. It got me to in my right mind state of mind. And
yeah, for right now. See, and that's what worries me.
I'm good. I got this. I promise on everything. I will do everything I possibly needed to do.
I want the same Taran Brown to show up at sentencing that I'm seeing today.
Will do.
I've been promised that many times and very.
Besides the crying.
All right, I'm going to set bond as requested by the defense attorney, $2,500 cash or surety. I hope you can make it, Taran, but just make sure that you show up for court when you're supposed to and do those assessments. You're obligated to call court services as soon as you make bond and get set up with them for these assessments. Okay?
Will do.
All right.
Thank you.
All right. Just don't let yourself down, Ms. Brown.
I will not. I got 2 babies looking forward to me. So
$2,500 cash or professional surety is established as the new bond in the case.
Thank you.
If there's nothing further, the Taran Brown matter will be in recess at this time. We'll move on to another matter.
What's your next court date? That's the time. And I give you I'm here, call court services.
I hope that she makes it. The truth of the matter is she was involved with some pretty heavy drugs that are very powerful, that are very difficult to break a habit with. And she needs a ton of support to make that.
Identify this individual, Mr. Favre.
You can't.
Judge, this is Miss Christy Rose Ginsburg.
It's the State versus Christy Rose Ginsburg, case number 24-CR-353. Amber Norris appearing for the state. Joseph Favre's defense counsel. Defendant Ginsburg appearing from the jail Zoom location.
I like this.
What announcement is made today?
Man, he's good.
Judge, Miss Ginsburg has been advised for right to an evidentiary hearing. At this point, she's going to waive her right to an evidentiary hearing, and she's going to enter a plea to counts 1 and 3 of the information, which is level 5 possession of paraphernalia for distribution and level 10 tax stamp. State has agreed to dismiss remaining counts. At sentencing, it's anticipated Ms. Ginsburg will likely end up being border box, and state has not agreed to take any particular position, but she will intend on making border box findings at the time of sentencing.
So 1 and 3 and dismiss 2?
Dismiss 2. So dismiss methamphetamine, plead to possession of paraphernalia, and plead to no tax stamp.
So I wasn't anticipating these pleas today.
Trying to be efficient, Judge.
What did you think was going to happen, Judge? You're here for...
And Your Honor, that is state's understanding. The defendant would be pleading to counts 1 and 3, and state would be dismissing 2, 4, and 5.
Do you think he's just going to ask
Ginsburg, you've heard this announcement. Are you in agreement with it?
Yes, Your Honor.
All right. I've got a number of questions I need to ask you. If there's anything you don't understand, I will give you the opportunity to confer privately with your lawyer. Just let the court know if you need that time to get further advice, okay?
Yes, Your Honor.
State your name for the record, please.
Christy Rose Ginsburg.
How old are you right now?
45.
What's the highest level of education that you've attained?
9th.
Have
you ever been adjudged to be mentally ill?
Yes, Your Honor.
Okay. What's your diagnosis?
Manic depressive, bipolar, schizophrenic, borderline.
When did you receive that diagnosis?
In 2016, I believe it was, or 2010, I'm sorry.
Are you on medication to address that?
No, Your Honor, I'm not.
Are you supposed to be getting it?
Yes, I am, Your
This
Honor.
plea.
Well, is your mind even clear enough to be able
Yes,
to
Your
hear
Honor,
the
it is.
plea?
Yes, Your Honor.
I just want to make sure you're not in some sort of impaired state because you're not receiving your medications.
No, Your Honor, I'm not. I'm okay.
Do you guys
You're
see
not
a Tommy
under the
Lee Jones in
influence
him
of
at all?
alcohol or any other drug, are you?
No, Your Honor.
And your mind is clear and you believe you have a full understanding of what's going on here in court?
Yes, Your Honor.
I'm seeing Tommy Lee Jones in him a little
You
bit.
understand the nature of the charge in this case in count one?
Yeah, there you go.
Which
Yes.
is possession of paraphernalia to distribute or manufacture methamphetamine, a level 5 drug felony?
Yes, Your Honor.
You understand the nature of the charge of no drug tax stamp on methamphetamine as a drug?
Yes, Your Honor.
All right. You understand that when you enter a plea of guilty, you are admitting these acts that are charged by the state?
Yes, Your Honor.
You also understand that when you enter pleas of guilty, you give up any legal defenses that you might have had to those charges?
Yes, Your Honor.
Are you aware that in any trial, the state must present evidence against you in open court? That any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you could present evidence at your trial and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means you could testify if you wanted to, but no one could force you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter pleas of guilty, you give up these valuable trial rights that the court has described.
Yes, Your Honor.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, Your Honor.
You also understand that when you enter pleas of guilty, you are giving up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, Your Honor.
You further understand that you
I like that
may
he takes these
appeal
slowly.
your verdict if you have a trial.
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgments of conviction after you enter those pleas.
Yes, Your Honor.
Are you aware of the possible penalties that could be imposed as a result of these guilty pleas that you're attempting to make?
Yes, Your Honor.
We going to go over those?
Let's go over those.
Let's go over them. I like the judge. He sounds like he's like he wants to make sure everyone understands
On the drug grid at
rights
level
and that they're giving
5
them
for
up.
count 1, in the most favorable criminal history category of I, you could receive as little as a 10-month sentence. In the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you said today, we do not know with certainty what your criminal history is. You, better than anyone else participating, should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of that research, as of the date of sentencing, that determines where you fall along the level 5 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, Your Honor.
Keith, that's
you
awesome.
also understand that if you have a
Congratulations to
person
him.
felony on your record already, you are presumptive prison on that grid. You understand that?
Yes, Your Honor.
On the non-drug level 10, count 3, in the most favorable criminal history category of I, you could receive as little as a 5-month sentence. But in the worst criminal history category of A, you could receive up to a 13-month sentence. So the sentencing range on that offense is 5 to 13 months in prison, depending on your criminal history. Do you understand that?
Yes, Your Honor.
All right. Do you also understand that you could receive up to a $100,000 fine for not only the level 10 offense, but also the level 5 drug offense?
That is a huge fine.
Yes, Your Honor.
You also understand the difference between consecutive and concurrent sentences?
Yes, Your Honor.
Consecutive means boxcard, back to back. You serve all of one before you start to serve the other, obviously resulting in a longer sentence. Concurrent sentences mean they run all at the same time. When you're serving one, you're serving the other. Do you understand that generally it's up to the court to determine whether your counts run consecutively or concurrently?
Yes, Your Honor.
Have you had an ample opportunity to discuss legal matters like that with Mr. Favre?
Very briefly, yes, Your Honor.
Do you want any more time with him now before we go further?
No, Your Honor.
Sure. No.
Are you satisfied with the services and advice that he has given you?
Yes, Your Honor.
Now, these guilty pleas you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
We're going to bail on this. I think I know where it's going to go.
Okay.
And apologize for doing this.
You understand that if there are any plea deals,
I've got Judge Simpson, and it looks like it might be heating up just a tiny bit, and I don't want to miss it because he's been really good about deleting everything right as it happens. So let's jump back to him.
Evening. And he said that Kayla Cooper was there as well. Devin Miller was there as well with his girlfriend, Talisha Green. He said that Kayla came into the bedroom and told Tajay that Sierra was outside and that she had shown up with a group of people and was looking to continue the fight.
What did he say happened next?
He said that Tajay, Kayla, and Tajay's friend Genesis all decided to go down into the east side of the parking lot area, or that exit out of that east entry exit point, and that Sean Quest said that he followed them as well.
What did Sean Quest say? What did Sean Quest say he saw when he got outside?
He said he saw a group of about 4 to 5 females. One of the females that were out there was Sierra English. He said that they had arrived in 3 vehicles, that the vehicles were parked near the dumpster on the east side of the parking lot. Your Honor, you can see a dumpster here on this photo. I believe that's consistent with the location of where the dumpster was at the time of this incident as well. Once again, for a reference point, this is the east side of the building, and this is where the dumpster is. He said that there were 3 vehicles that showed up with a group of females. As I stated, one of the females that was part of this group was Sierra English. He said that he believes that at least 2 males had also shown up with the females. And then he said that Kayla Cooper was specifically interacting in the parking lot on the east side with Sierra and her female friends.
Did he indicate if anyone had any weapons?
He did describe at one point while the argument with the prosecutor was taking place that the females that Sierra was with in that group jumped Kayla with mace.
What did he say happened next?
He said as this was occurring, he heard one of the males that had come with the group of females say something to the effect of back up. He said the next thing he heard were gunshots, and he noticed muzzle flashes coming from the area where he believed that a male that he described as being black male, about 5'9", stocky build with an afro, had been standing. And then he saw, so he described this person as a person that he believed to be a shooter. He also described someone else that he thought was probably a male, or at least a male, but he couldn't describe that individual. But he also said that he saw what he believed to be a muzzle flash coming from that individual's location, but he wasn't able to get a good look at it.
Now, when you were having this interview with the defendant, did you have him create any visual aids to have the help further the conversation?
I did.
And was one of those a map, or was there a map that he created?
So we worked on a sketch together.
I mean a sketch, excuse me.
Yes, and as I was discussing with him how the events had transpired, I was writing on this rough sketch, and he was explaining to me where things happened and how things had been occurring.
Your may I have permission to approach the People's Proposed Exhibit 8?
You may.
Your Honor, I have an extra copy for the court.
Thank you.
I will put it face side down if that's okay, Your Honor.
That's fine.
Until it's submitted.
Do see a baby in the very back of court.
I place in front of you what the People's Proposed Exhibit 8. Is that a fair and accurate copy of the sketch that you and Sean Quest Lawson were working on during this interview?
Yes.
Or the admission of Pickles proposed exhibit 8?
Any objection of voir dire?
No objection.
Exhibit 8 is admitted.
Thank you. President, where did he indicate the males were when they were shooting at him?
Okay, so the stick figure that I have labeled shooter unknown, and I have in my notes muzzle flash, and I have indicated 3 cars, CC cars, one of which CC being Sierra English's vehicle. That particular individual, like I said, was shooting in his direction, in the direction of Tajay, Genesis, and Kayla, would have been in the south east area of the parking lot, what he described as being near the dumpster.
There are 2 rectangles on this map. What do those indicate? 2 large rectangles? Perhaps the buildings?
Yes. So yes, the rectangles would be indicating, and it's not broken up into the 2 sections that we can see on the map. But the one rectangle would have been basically what we've been discussing as 1460 share, and then also the building that's still part of that building, but a little bit of the building being extended to the west. So this is those 2 buildings together that's only indicated with this rectangle.
So the top rectangle is the entire northeastmost building, is that correct?
Correct.
There appears to be a gap. Can you indicate where that gap would be reflected on people proposed exhibit 7 up on that big map that's behind you, where that gap would be?
Yes. So parking lot. That's going to be, if that's what you're referring to.
Yes,
yeah.
thank you.
So on this map, which is much less improved my drawing, it's going to be this parking lot area, Your Honor, right here. So the rectangle that I wrote on the rough sketch is going to, or drew on the rough sketch, is going to be this entire structure.
So where does he indicate the males are when he's being shot at?
So do you want me to refer to this?
Nope, let's refer to your sketch.
So the way he described it was that this first shooter, who we did not get a good look at, he described it as being near the dumpster. He said that he saw a muzzle flash, but didn't have any other details about how this individual looked.
And what does he say happens next?
He said that shots started coming from what he believes were both of these individuals in the direction of where he was standing, along with Tajay, Genesis, and in the general direction of Kayla. Kayla was a little bit further into the parking lot, involved in a fight. He described his location as being standing on the steps right at the entry-exit point on the east side of the building. So he's actually standing on the steps of that location.
What did he do?
Right next to Tajay.
Sorry to interrupt you. What did he do next?
He said as he was being fired upon, he stated that he, Genesis, and Tajay ran into the building on the east side. He said that he ran upstairs and got a Glock 43 9mm firearm inside the apartment at 1470 Sheriff. He said that shots were continuing to be fired, and he could hear them as he was running into the building, up the stairs to recover the firearm, and then running back down in order to then exit out the east-west entry point.
What happened next, according to him, after he retrieved the firearm from the apartment?
He said he was standing on the step when he started shooting in the direction of where he believed the shots were coming.
Which step, the east or the west step?
The east step.
What did he say happened after he was shooting from the east steps?
So I asked him how many shots he fired, and he said that he shot about 5 to 6 shots in that direction. He also made a quote, if I could refer to my report.
Would that refresh your recollection?
Yes, it would.
Your Honor, there's no objection from the Court of Defense when you review this report? No objection.
Can hear the baby there in the back of court. So he got shot at and then returned fire and
he said, I went to the front door and just let off shots at the front door. I seen them taking off, so I'm like, okay, boom. It was just that.
Okay. What does he say happens after he is standing outside of the east door?
They were
shooting?
running away?
He said after he fired off the shots, he went back into the building and was standing in the hallway, which runs east to west. He said that Tajay and Kayla and Genesis were standing in the hallway. He said that there was a discussion that took place about the fact that perhaps not everybody had left at that point, because he had described that he saw at least one of the 3 cars that showed up leaving the area. He said that there was a discussion about maybe not all the vehicles had left, and so therefore not everybody who showed up had left, and that there was a belief that maybe somebody would try to come on the west side of the building and try to make entry into the building from that west entry exit point.
What did he say he did next?
He said that he went over to that side of the building and partially stepped out of the door. And when I was speaking with him, and he's now in possession of the Glock 9mm handgun, he pointed his hand in the air and said that he fired off 2 shots into the air as he quickly stepped outside of that particular west side.
What did you say to him concerning that statement?
I had been to the scene and I was aware of the fact that there was a fixed awning over that doorway, which was a solid structure. And so I said to him, if you would have been shooting as you're describing, I said I would be expecting to see bullet holes.
Were there any bullet holes in that, what I'll call sort of awning roof structure?
No, there were not.
What did he say?
He then changed his statement, Your Honor, and said, and showed me and demonstrated that he instead had leveled his firearm in the direction of where he believed that one of the shooters had come around on the west side of the building.
Did he indicate anyone was shooting at him when he fired that firearm on the west side of the building?
So he said that when he came out that west side, he saw the person that he had described to me as being the shooter with the afro. He said that he initially told me that he had kind of just started shooting in that direction and that he wasn't trying to hit anybody. But then he changed his statement and provided a quote to me that if I could refer to it.
Would that refresh your recollection as to the quote you provided?
Yes.
So please review your report, and when you have it, go ahead and let me know you're ready. And please don't read from the report, but just say what the quote was. You ready?
Yes.
Go ahead.
When he stepped out on the west side, he said, as soon as I seen him, I just got to shooting.
I just got to shoot.
I just got to shooting.
What does he say happened next?
This doesn't sound like self-defense.
He said that after he had stepped out and fired 2 shots, that he quickly went back inside the building and went upstairs. I asked him if the person that he had been shooting at shot back, and he says he indicated to me that he didn't know.
What does he say happens after the shooting is concluded?
So one of the things that I had done with him is also, as part of the sketch, gone over where I knew the victim had been struck.
And what did you say to him about that?
So he and I went over the fact that the victim had been struck right where this red pin is located. And so I wanted to discuss with him where this person who he described as the shooter with the afro had been located when he shot at him. And he told me initially that, and this is also consistent with what we were working on with the drawing, he told me initially that the afro, the person with the afro that was shooting was in this general location where this red pin in. As we continued to discuss where that person had been located, he said that that particular shooter was more in this southwest corner of the parking lot. And he was very clear to me and that the shooter never left this southwest parking lot area. Based upon where he was now saying the shooter was
Selena,
located,
thank you.
I asked him if he saw anybody
5 members
in this general location. If he saw anybody kind of in the path or trajectory of where
Good
he was
luck on your
shooting,
recovery, Selena.
I
We're
even
praying
brought
for
up to
you.
him if he saw anybody with a cigarette or anything along those lines. I was aware of the fact that the victim, when he had been found, had a cigarette in his hand. Mr. Lawson said that he didn't see anybody standing at that location.
The judge is ready to be done for the day. I've never seen him this antsy.
Did he make any indication to you if he was aware anybody had been hurt?
So I asked him, and this was after he had indicated to me that deputies had arrived on scene, and that he had, after the shooting, gone up to the apartment 1470 and given his firearm to Devin. I asked him if he was aware of anyone being shot, and he said he didn't know about anybody being shot, but that he had heard one of the deputies indicate that somebody had gone to the hospital. Later on at the interview, very close to the end of the interview, I told him, well, yes, somebody has in fact been shot. And I said to him, I indicated to him the location of where the person had been shot. And I asked him again, like, are you aware of anybody being in that location? And he said he didn't see anybody.
Deputy Bryson, we have some questions for you about this sketch versus this map. Were any casings recovered, fire cartridge casings recovered from that parking lot area and that space between the two buildings?
There were no fire cartridge casings located in that area.
Where were they located?
The casings of the smaller caliber that eventually were positively identified as being 9mm were located on the east side of the building.
Thank you very much. 6 months.
And 2 fire cartridge casings on the west entry exit point on the side of the building.
Are you aware if those fire cartridge casings were found to be consistent with the Glock 9mm that was recovered in Devin Miller's vehicle?
Yes, I'm aware from a review of lab reports that those fire cartridge casings are all 9mm fire cartridge casings, and that they were matched to the Glock 43 9mm handgun, which Sean Queslawson told me was in Devin Miller's trunk.
What did he tell you how it got in Devin Miller's trunk?
Yes, he did. He said that after the shooting, he went up to Tajay's apartment, 1470 Sheridan. He said he gave the gun to Devin Miller, and Devin Miller then left the apartment. He estimated it was about 40 seconds to 50 seconds that Devin Miller was gone, and that the firearm was put in Devin Miller's trunk, and then Devin Miller then came back up to the apartment.
Were any fire cartridge casings found near the dumpster that you indicated is present on the large map, Pickles Proposed Exhibit 7?
No.
Were any fire cartridge casings that were not 9mm found in the southeast corner of this map?
There were fire cartridge casings in the southeast corner of the map, which is indicated by this blue-green pushpin.
Have you visited this scene in person?
Yes.
Is there a direct line of sight from the west door where the 2 fire cartridge casings were to the location where the 40 caliber cartridge casings were?
There is not.
What's in the way?
Well, we're talking about opposite sides of the building, number one. We're talking, if you're asking about these fire cartridge casings from here, I cannot foresee a scenario where if somebody was shooting from this location in the south direction, they would be able to see anyone shooting from that location.
Were there any other casings located in this scene besides the ones you've identified previously?
No.
Were there any bullet holes or bullet hole damage located on the east side of the building?
On this side of the building, this east side, and even extending further south on the east side of this building, there were no bullet holes found.
And what the defendant told you is that he was standing outside of there being fired upon?
Yes, he was standing at this location and receiving multiple gunshots in his direction.
And you're indicating the east side of the building, near that yellow marker on the east side, is that
That's right,
correct?
east side of the
So he may have been
No
lying about
bullet
getting
damage
shot
found in the
at
building.
before he shot at somebody else.
No bullet damage.
How about on the vehicles?
I observed bullet damage, and this is an approximation. Obviously, this isn't the actual location of the vehicles. But I believe there was in this general area, and may have been indicated by this green pin. There was, I believe, a Subaru parked in this general location, Your Honor, and there was a bullet recovered, a 9mm bullet recovered from that vehicle, which matched the 9mm Glock 43 that Sean Quez and Lawson have been using.
Do you recall the approximate location of Devin Miller's black Ford Fusion outside this apartment building?
Yes, I do. So Devin Miller's approximate location of his Fusion would have been area here, Your Honor. Just parked in one of these spots, not too far from that east entry exit point.
Looks like you're indicating more sort of a south-south direction from the east entry point, is that correct?
Yes.
You may.
So prosecution sitting out a pretty good case showing the defendant might have been the only person firing that night. There's no bullet casings. There's no bullet damage, even though there was a lot of firing all the time. He was running inside, running upstairs, getting his gun, coming back downstairs. No evidence that ever happened. I think this is a preliminary trial. I think it's
Judge Bryson, when you were interviewing the defendant and he told you about hearing that statement of back up, did he indicate to you where that may have been coming from, where he heard that from?
Wasn't able to be specific other than he heard a male say back up, and then the shot started happening.
Thank you. Judge Bryson, did you do any additional investigation into the deceit, the victim in this case, Antonio Brown?
Yes.
Did you understand what association or connection he might have to the location of this shooting?
His mother lives in the complex. I know he has a sister as well that lives in the complex. But beyond that, and actually, I think he may have lived either one of those at one point or at the time that he was killed.
Thank you. Amanda,
She's getting a lot of help from her second and third chair. Let's see if defense has any questions here, if she's done. No, she's not done.
And Your Honor, people would look at the...
You said. Okay.
Thanks, John. People would look to the proposed exhibit 7 for demonstrative purposes, which is the match.
Yes, I did notice that. Any objection?
No.
All right, exhibit 7 is admitted.
Thank you, Your Honor. I'll pass the witness.
All right. Before you cross-examine, I just want to make sure I'm understanding this drawing. That there are two rectangles, or kind of rectangles. The top rectangle that's on exhibit 8, that represents both buildings in that top portion. Is that right?
Yes, Your Honor. It's going to be both of these buildings right here.
Got it. Okay, I just wanted to make sure I was seeing it right. Ms. Young.
Thank you.
Okay, we're gonna bail. We're gonna bail. I know it's later in the day. It's 5:30 or 5:20 basically for most of y'all. I'm gonna try to be on earlier tomorrow. We're gonna see if we can follow a couple things. We've got the Judge Jumper case tomorrow. We're gonna see if we can get to you, which should be interesting because that's plea by reason of insanity, right? I think they're trying to say that he's out of his mind. Oh, I think he was to do something like that, but we'll see that. That's an attempted murder coming up. We've got Carly Gregg, who should be in jury selection here shortly, if not already, going as well. Diobra, I think it's Diobra. I'm going with Diobra. Redden is the bench jumper. We're going to try to bring that to you tomorrow as well. We might have some court hopping in the morning because I think that the Obra one, the Redden, starts in the afternoon Vegas time. So, famous last words. We're going to try to be early. Earlier. I was up too late last night. I was up way too late. And then I slept in a little bit this morning. And then I had the technical issue this morning trying to reconfigure all of my electronic stuff because the router, I don't know, it's like they switched internet providers. Everything was different. And so I had to reconnect and reset up everything. So it's still a pretty day outside, even though it's a little bit overcast here. Well, it's only partly cloudy. See if I can show that. There we go. That's a little bit better, right? Show the clouds, just the iris a little bit. Oh, not all the way down. Get that blue sky popping. There we go. There's a tiny bit of blue sky visible as we look over the mountains and the trees. Sweet Tat says, I just took my seat. I just got here. Just got here. I love good sarcasm. It's wonderful. All right, so we've got a couple things coming up, a couple cases that are coming up. Obviously, I am still on vacation, workation. My schedule, my son gets married this week. Yay! I should probably do like a celebration thing. I think I've got an applause button here somewhere. There we go. My son gets married this week. So big congratulations to him. I'm nervous as I'll get out because I'm not old enough to have a married kid. But we're going to be up in Idaho, and then I'll be up there pretty much for the weekend. Then come down here Monday to stay in Salt Lake overnight, only because we booked a hotel when we thought we were going to fly out. We thought we'd drive back to Idaho, from Idaho to Salt Lake, stay the night, then hop on the plane, fly out. But because we're driving, now we do like a 2 or 3 hour drive one day and then wait for the next day. So, because we couldn't cancel that hotel. So we're going to stay the night in Salt Lake and then head back. Judge Simpson is going to have some spicy courts. Like, I think it's the 10th or the 11th. I forget what it is. I think it's the 10th and the 15th. We're going to be driving during some of these. So we're going to try to figure out how to live stream from the car during the day to follow some of these courts because I really want to follow them. And I think I can do it because I have different attachments and battery packs that can power various and sundry items. Let me think. How would I do my mics? Okay, I do wireless mics. I can do a battery pack on my switcher. It's going to be crowded there in the passenger seat. I can tell you that. It's going to be crowded. But anyway, yay, a wedding, then you're going to have grandbabies. At some point, we anticipate that would follow. But then we are headed home. Yes, we're driving home. And we're taking one extra day driving home than we took on the way here, just because those long days of driving were no good. So we're taking one day. I don't yet know the route. Mrs. R.A. knows the route. I need to work RV. Oh, that would be awesome. The neighbors across the street, actually, from where we're staying, just bought a huge, like, travel RV, like one of those big diesel pusher RVs. It's basically a bus, right? But it's like Coachman or something. It's one of those nice ones. They just bought one, and they're actually renting it out. So maybe we should just call them and say, hey, if we advertise for you, maybe you could just let us rent it for free. I don't think they'd go for that. But let's see. Headed for Grizzly for more gruesome details about Maddie. Oh, man. They are gruesome details. But it can never go wrong with Grizzly. Grandbabies are the best, says Debbie. Is that not distracted driving? It isn't. Only if I'm driving. Keith, I was not going to be driving. Mrs. R.A. would be driving. I would be running the show from the passenger seat. What's the gallons per mile? I think it's 1-to-1, Corey, on those big, huge pushers. You don't, I mean, if you're getting the double digits, you're really making good time. Gonna gain a daughter. Yes, and she's amazing. We've met her. She's wonderful. We like her. A great addition to the family. He's got good taste. All the things. We're excited about this. But I'm not excited about the whole wedding. using that data down the road. I've got my live view. I pay for a live view that has unlimited data, so I can push to the internet unlimited, like 24/7 all month long. I can push a 4K signal to the internet. That's what I pay for, and I use just a fraction of that, and the rate is the same. Recovery Addict is a passenger princess. So no running red lights. Thank you, Jim Bob. I'll try to remember. What day is the wedding? I think like Thursday or Friday. That's it. Going to start some dinner. Take care, everybody. Stay safe. Thank you again. Hey, you're welcome. Thank you very much for being here. Appreciate that. Thanks for the two uncivil law raids today. I appreciate all the uncivilians who popped over here. Thank you. Appreciate Kurt sending you guys our way. And I think that'll do it for me. I think nap time is in order tonight. Shouldn't you know when the wedding is? I just go where I'm told, Gilly May. I think you should know. Just tell me when I need to pack up my stuff. I'll have it ready and we'll go. And I'll be good. Friday, RA is leaving 3rd, I think. I think it's Friday. We leave the day before. So we leave Thursday, the wedding's on Friday. It's really quick as far as the turnaround time. So tomorrow time, I'll try to be earlier. How about that? That's all I can say. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live tomorrow morning. I've limited myself to pre-noon Mountain Time. How about that? No, we're gonna be on early. I think the court case with Redden starts in the afternoon. That's the first one. I think we're gonna be watching the big one moving forward, but we'll do some court hopping right before then to get ready. Hope you all had a wonderful day today, whether at work or at home or somewhere else on the road. Glad we could keep you company. Thanks for bringing us along. Thanks for clicking the subscribe button, and bring a friend next time. It's a lot of fun. AM is a safe bet. I wish I could give you a time. I don't know, because I've got some things we have to do. Like I'm going to go get my suit from dry cleaners, and there's things like that, and I only have time in the morning, because in the afternoon the car is gone right now, so I'm stuck here. But that's all. Green-eyed Cat, welcome. You guys have a good night. Be good to each other. We will see you in the morning earlier than today. That's all I can say. You guys have a good one. Bye-bye.
Alex stole it. And Ellen Murdoch stole it. Alex stole it as well.